Loading right now. There we go. We are live. Well, hello everyone. My name is Mike Kelly and welcome to Money in Life TV. And oh boy, I am so excited because I have a very close friend and colleague, Gina Leguria, here with us today. Gina, how are you?
I'm well, Mike. Thanks for asking. How are you doing?
Doing great. Thanks. You know, you're a hard one to pin down. You're very busy. And so I've been wanting to have you on stream for a long time. A lot of my clients whether they're in California or across the United States, they're always wanting to know about estate planning and trust and like, what does it mean? Like, how does it work? And why is it beneficial? So today's session is really just going to be educational. And so I hope to, bounce some questions and ideas off of you, and hopefully you can share your wealth of knowledge with the audience. So you've been doing this now for over 20 years. Is that right?
That's right. More years than I care to count.
Okay. How did you get started in this? Like what led you to start doing this line of work?
Yeah, that's a great question, Mike, and thanks for asking. And I know you know my story, but I'll just share it really quickly. So when I was in my early 20s, my dad was killed tragically in an automobile accident. And I had younger brother and sister. My sister was only 12 years old at the time. And our family, he had nothing in place. He was 42 years old, and nobody thinks they're going to die, right?
42. Wow. Yeah, I'm like only 5 years away from that.
Yeah. Oh, scary.
That's scary. I'm getting nervous right here.
Yeah. Once I hit 42, I thought I arrived. So different perspective. But in any case, without any planning, my family spent 4.5 years in the probate court. We were tied up in everything. Everything that could go wrong did go wrong. We had a minor, we had business partners, we had some real estate to deal with. So it was just a hot mess, for lack of a better term. And that was emotionally draining. I was appointed to be in charge of the estate as the oldest heir. And it was really, really tough on my family. And when it's all said and done, there was nothing left.
Nothing left.
Worked his whole life, tried to build a legacy, and zeros, nothing left. So that saddened me. And I learned a lot in the process and worked with the attorneys. And I just was called to do this kind of work. I just decided, nobody should have to go through this. So I actually enrolled in law school with the express purpose of being an estate planning attorney.
Wow. Okay. That's pretty cool. That's pretty neat.
Yeah.
And so when you say probate, like, to the average person, what should that mean to the average person when you say something gets tied up in probate?
Yeah, probate. So probate is a court process that we have to go through in order to transfer somebody's real property and other assets to their heirs. And so it is a highly regulated court process. There's a judge who presides over everything. It's a lot of filing. There's hearings involved. The deadlines are very unforgiving, and the paperwork is meticulous and tedious. So you check one thing wrong and you end up with a great delay. And I tell folks, if you don't do any planning, the state has a plan for you.
Oh, that's brutal.
Yeah. And it's called probate. And on average, I would say in the counties where I do most of my practice, it's about 18 months, sometimes as much as 2 years. So, and that's if everything goes well. If every deadline is met and every box is checked, it can take that long. So that's a real drain on your family, financially, emotionally, just everything that you have to go through just to pass on your assets, your house, your bank account, everything to the people you want it to go to. So to your heirs.
Wow. That's brutal. Now I've seen where, I think I was working on an estate, from as you know, I'm from the tax perspective, where I think they must have dished out like over $30,000 to $40,000 just to probate. So,
yes,
it's a very large financial drain on anybody's inheritance, and
it is
just the estate in general. So how does a person, so we talked about probate and what that means. So there's a very lengthy process before you can gain control over those assets and distribute that out. And of course, the financial consequences. So what can people do to remedy that? Is there a way around the probate, and what should people know?
Yeah, so there is a way around it, but I want to make one quick note because I talk to people all the time who say, "Oh, I have a will." And I have to say to them, "Oh, good. You have a probate." Where there is a will, there is a probate.
Oh, that's easy
Basically.
to remember.
Yeah, and so a will's a great first step on an estate plan because it does in fact document your decisions, where you want your assets to go, who you want to have in charge. But unfortunately, that will is supervised by the court and goes through the same probate steps as if you did nothing. So it's just an expression of your wishes that is carried out by your executor with oversight from the court. So the process is the same whether you do nothing, like my dad did, or have a will. So
Oh,
that
interesting.
is not necessarily a good estate planning tool for everybody. Now, you asked, well, what do we do instead? And the way that I practice is we recommend that people put their hard-earned assets into something called a revocable living trust. And you go, I don't have much. I don't need a trust fund. And I say, well, a trust fund is really for everyone. A trust is a way to keep your family out of probate and have your wishes followed. So, I don't know if you can see this too well, but I just tell people, think of your trust as a box, right? Here's my box. Here's my trust box. And I'm going to put my house in the trust, and I'm going to put my investments in there, and my bank accounts and any other tangible assets that I have. I still own this box. This box is all mine. I control it. I control everything in it. So I'm not giving anything up. But then when I pass away, my successor trustee, the person who I pick to be in charge of my box when I'm gone, they can take all the assets out of my box and give them to the people where I want it to go. My heirs, my children, my charities, my pets, my college, my church, wherever I want anything in my box to go, my successor trustee can take care of that, and we don't go to court.
Wow. So just by going through that, so just by doing that process, you just avoid so much headache.
You do. You create that revocable living trust. And I stress revocable because people say, well, what if I change my mind? And that's why it's revocable. You can amend it. You can change it. You can update it. It is whatever you want to do because it's an expression of your intention and wishes on who's in control and where your stuff goes.
Okay. And that's like the revocable is the revocable living trust. That would you say that's like the most common trust you see or that people would generally need?
Yeah, I would say by and large, it is the most common one, but the sad fact is that 68% of Americans have no estate planning in place whatsoever. None. And
Wow.
of the 32% that do, just a fraction of those actually do the revocable living trust because of that myth or that misnomer that you have to have millions and have properties and be a celebrity, an athlete, somebody with tons of money to do a trust. It's for everyone. It's for anyone who wants to control what happens to their estate when they go.
Okay. So yeah, because I hear that a lot. So especially as like a CPA, if I'm talking to somebody about their taxes and then I bring up, hey, do you have any sort of estate plan in place? Have you thought about that? And often I'll hear like, oh, well, I'm not rich enough to need that. I don't need that. So,
Yeah.
is there you're alluding to the fact that like, it sounds like most people would benefit from a trust. Is there a certain dollar level of assets you think one should own to benefit from having a trust? Or is there any like threshold people should be aware of to determine if they need one or not?
Yeah. So in California, where I'm located, any assets over right now, it's a really strange number, $184,500.
$184,500.
Yeah. So if you have 184,501, you're in probate. Yeah. The other thing is real property. Real property is very tricky. There are some other ways if it's real property of very small value. So maybe like a postage stamp lot somewhere with, like $10,000 value or something. That may not necessarily have to go to probate, but really, if you have real property or you have assets over $184,500, you should consider doing something like a living trust from the economic and financial aspect of it.
Okay.
Yeah.
Okay.
Yeah. There's other reasons though to do a trust. So let me just touch on a couple of things. First of all, you want to have somebody you trust, trustee, in control of what you work so hard to build, right? If you don't do anything, there's a list of people who could come in and raise their hand and say, oh, I'll be in charge of their estate when they're dead. And it might be someone you don't even care for. You know, it could be your long lost brother that you haven't talked to in 40 years. He would perhaps have priority if all of your parents were gone, your spouse, your children. So there's, you know, laws and hierarchies of who gets appointed. To me, I want control of that. I just don't want anybody, you know, stepping in saying, oh, I'll be in charge of the estate. So I want to specify who's in charge.
Sure.
Yeah.
In fact, I think you answered that question, I think, right at the right time. So we had a couple comments. So Great Transportation says, hi, Mike and Gina. Is there a dollar limit that an estate doesn't go to probate? So in California, like you said, it's about 184,000 would be that threshold. And then Great Transportation also asked, does that limit vary by state?
It does. Yeah. Every state is different. So your state should have a probate code, and it will specify exactly what amount would need to go for probate or not probate.
Okay. And then, you know, people often ask this, and I think I asked myself in the past, like, how does this work? And so I would love to hear your take on it. So I don't know if this is like a myth or a misconception, but if you put property or assets in a trust, does that give you, in your opinion, any additional asset protection for the assets held in that trust?
So again, it varies by state. Some states have very liberal laws regarding domestic asset protection. California doesn't recognize a domestic asset protection trust. So there's other planning tools that we have to look at. But for most people, if they're not in high risk occupations, that's not really an issue. And insurance is very prevalent. You have automobile insurance, you have liability insurance, you have homeowners insurance. So that's always sort of the first line of defense for that. But it varies states to state. And I would say if somebody is interested in that from another state, I can certainly recommend a colleague in that state. I have colleagues in just about every state in the US. They can advise them on that.
Oh, that's great. Because on this channel, I have viewers like all around the country. So happy to make a referral. Super helpful. Yeah. And I'll let you guys know, I just want to take a moment to express like how grateful I am to know Gina. So I met her it's probably 7 or 8 years ago now is when we actually met. I met her at a conference, and just the way she was able to explain things, it really caught my attention. And when she explained like how a trust works, a light bulb went off in my head. It just clicked. And so since then, you know, all the years I've been working as a CPA, whether I'm, you know, now I'm in my own firm, of course, but even before then, I think, referring family, friends, even some of my coworkers like, hey, do you know anybody in the estate and trust realm who can help me set up a trust? And I'd always drop your name because I said, I know Gina is very good at what she does. And when I refer somebody to you, Gina, like, I don't even worry one bit. Like, I know they're in good hands. I don't even stress about it.
Well, thank you.
And it's hard to find people that I can honestly say that about. So I really appreciate all you do, you know, in regards to that. And so,
well, I appreciate you and thank you. So Great Transportation asks a really good question here. Are there tax advantages to putting assets into a trust, or does it streamline the process? So Mike, you can comment on this because, you know, the federal estate tax exemption is so high right now that unless somebody's a super high net worth individual, we're not having to do a lot of tax planning at this point.
Right.
Yeah.
Right. So that's a wonderful question. So like with a revocable trust, I think a common, maybe it's a misunderstanding I find people have when it comes to trust is if part of their fear of forming one is they don't want to drastically alter their tax situation.
Oh, yeah.
They're afraid, which is a great question, or a great,
Yeah.
I would be thinking that too. I'd be like, oh, well, revocable trust sounds great, but if I put my asset in a trust, it's going to complicate my taxes and it's going to just make things a mess. And actually, that's actually not true. So the wonderful thing about a living trust or revocable living trust is that when you put those assets in the trust, since it's revocable, it's still as if you own them in a sense. So for tax purposes, literally nothing changes.
Right.
And so it doesn't give you an edge, I would say. Like, it doesn't give you like a tax advantage or disadvantage, but it does help you prepare for, avoid probate in the future and really make sure your assets are going to where you want to direct them to go. And so ultimately your beneficiaries get the smoothest inheritance possible for those who you care about the most, right? Now, there are situations where it would alter your tax situation, and that's if you, there's different kinds of trust. There's like charitable remainder trust is a great way people use trust to donate to charity and get major tax benefits from it. There's charitable lead trust. Which some of this stuff is so foreign. It's like, what the heck is he talking about? But there's all these like unique trusts out there. But the other most common one that I see pretty often is, I would say, like an irrevocable trust. So like what is an irrevocable trust, Gina? If I were to ask you, like in a nutshell, like what is that?
Sure. So you have the revocable one, which you are just standing in the shoes of the trust, and it uses your social security number, and you have complete control of those assets. On the other side of that coin, you have the irrevocable trust that's now its own entity. So it does get its own tax ID number, and you are giving up control of those assets. So you're putting a trustee in charge of them. You can get the benefit of those assets, some of the income benefit off of them, but you can't exercise control or dominion over those assets. So you have to be working with someone, a trustee who you really trust, to carry out the intentions of that irrevocable trust. The most common form for that is when we're needing to do planning for individuals with special needs. Maybe they are on Medicaid, or here in California, we call it Medi-Cal. And so there are some irrevocable trusts that we can use. So someone could still get an inheritance to enhance their quality of life, but keep that safety net of public benefits. So that's really important. And we can do that through trust planning, through the irrevocable trust, and also some special provisions in a revocable trust. That's one really big advantage about having a trust in place, is that if you have minor beneficiaries, or you have individuals with special needs in your life that you're caring for, a trust is a great way to protect them. They're vulnerable. They can't manage that money. And if something happened to you, you're going to need a trustworthy individual to make sure that that person is cared for if you're not there to do that.
Yeah, absolutely. No, that's a fantastic point. So there's so many like reasons just beyond financial benefits to form a trust. And one reason, like I know people will often look at irrevocable trust is, now I know the exemption for estate taxes has gone up dramatically, right? Most people are not going to have to worry about that. But if for the high wealth individuals out there, they will often use like an irrevocable trust or a similar kind of trust they lose control over those assets because they put them in the trust, and but that gets the asset out of their estate for estate tax purposes. So they're trying to avoid that estate tax on the federal level. And I don't know if most people know this, but for every dollar above the estate threshold that you have, the government gets 40%. So they tax you throughout your entire life on your income, sales taxes, property taxes, taxes on your cell phone, taxes on you name it. There's taxes pretty much on everything we do. And then if you're too wealthy, then they tax you again, but at 40%, and then your family gets whatever's left over. So it's really interesting. So a lot of people try really hard not to give that money to the government, as you can imagine.
Yeah.
Couple of questions coming in here. So Cable Red says, "Hi Gina. I'm wondering about putting my 401k into a trust. Would that protect me or it in case of a divorce? Do people do that?
Yeah, so that's a good question, and it's pretty technical, but we typically don't put the 401k in the trust. That is what's called a qualified asset. And so it needs to be owned by a real person, you, the person who earned the 401k or the pension or the annuity, the IRA. And then ERISA law or federal law says that you really have to name your spouse first, or you get a qualified disclaimer of those benefits from that, and it has to be notarized. So oftentimes retirement assets in a divorce situation are the prime asset that gets divided up in divorce court. So just putting it in a trust, we wouldn't do that in the first place. I can't think of any custodian who would do that. But certainly, you could do some planning around the 401k. If you did get a divorce and you still have a 401k, and of course you don't have a spouse now any longer, maybe you have minor children. So you would name the trust as the beneficiary of the 401k. And then there would be certain provisions in the trust to make sure it wasn't taxed at a higher rate and the like. But I just really want to say this is, I'll call it my public service announcement. Don't put your minor children as beneficiaries. It creates so many issues down the road if something happens to you. So you need to have other options, and we can do that through the trust or some other type of, it's called gift to minors accounts. And, so just, we have a child and we want to put their name,
Sure.
I wanted to go to them. That's just like a heartfelt feeling, but it creates just so many issues down the road.
Oh, wow. That's a great point. Yeah. Because if they can't really be, if they're not of age to receive the money, it's just going to create a bit of a nightmare for them or for whoever's trying to administer the estate.
Yeah. And depending upon the amount, we could end up in guardianship court. So that's a whole
really? Oh, wow.
Yeah. So you don't want to do that.
See, all this stuff should be taught in school. I think this is what we need. This is what we actually need to know. Not a lot of this other stuff that we're.
Yeah. Finance 101.
Yeah. Annie asked a great question. She says, do you need to be employed? Do you need to be employed to have a trust?
No. Oh, no. I have a lot of unemployed people, retirees, or, folks that have other, sources of income or to have a trust. Yeah. It's really, based on your assets and your needs. What do you need? What do you need to protect? Think of it as we're protecting your assets and carrying out your legacy.
Okay. Very cool. Sewer Rat says, my mom passed away. I had a power of attorney over her. I put my kids as a beneficiary over her money. I mess up by doing that. Now I got to go to court to be a guardian for my kids to manage the money until they're 18.
Yeah. Oh, I'm so sorry.
Oh, I'm sorry, yeah. Sewer Rat.
Yeah.
I love your screen name, by the way. I love your picture of Shredder awesome. from Ninja Turtles. So my viewers here are pretty awesome. So you never know what their screen name is going to be.
That's kind of a fun one.
Okay, so let's let's continue on. So obviously to going back a little bit and talking about how like a trust can help you like sidestep probate.
Yeah.
What is now? Obviously, I'm not asking you directly, Gina, but in general, what do you think for the average person? Does a trust cost to form? And I know it varies by who people go to and who they work with.
It does, and it varies, state to state, community to community. Here in California, things in the greater metropolitan areas like Los Angeles and San Francisco and Sacramento tend to run a little higher than maybe some of the inland communities or more rural communities out there. But I would say it's everything from a $1,500-$1,800 up to $6,000-$7,000 and everything in between.
Sure, okay, that makes sense.
Yeah, but what I tell folks, and it's not based on your net worth. There's no little formula here that says, "Oh, you're at $200,000, so your price is this." So
yeah, you're not. It's not like people are charging a net worth fee. Like, oh, well, if you're this rich, I'll charge you this much. It's not how it works.
Yeah. The more complex your plan is, that you're probably going to be on the more higher end. If you're a high net worth individual that has a lot of tax planning issues where we have to coordinate with CPAs, and maybe there's partnerships and businesses and all kinds of things going on. But, you know, the basic hardworking folks who own real property, their home, their car, their, you know, the retirement assets, bank accounts and things, I would say fall somewhere, you know, in the middle.
Okay.
Yeah.
That's good to know. And I think, I mean, as I learned like more of how trusts work, and I thought about how expensive probate is, because isn't like in California, isn't probate about 4% of the assets?
Yeah.
So if you have, here's how I personally think of it, just me personally, but like, so if I have $1 million estate or even 500,000, if my assets have to go to probate when I pass, then, you know, that's a $20,000 to $40,000 fee right there that my beneficiaries do not receive.
Yeah.
So the way I view it from an economic standpoint, besides all the other benefits it yields, is okay. So I'm going to invest maybe a couple thousand, right, to form that trust. I'm going to take the time to do that, and by doing that, my heirs are going to get $20,000 to $40,000 more, approximately, in their inheritance versus it going to the local government.
Yeah. Cost avoidance, cost benefit analysis. But, you know, even equally important though is you get to decide what happens.
Yeah.
And that is such a peace of mind, knowing that who you want to be in charge is going to be in charge. And the people that you want to receive what you work so hard for are going to get it, without all this machinations and people coming in and claiming and, you know, that's my father, you know, ancestry DNA and all kinds of things.
That is my daddy.
Stuff happens in probate.
Oh, I believe it. It's like an episode of Mario or something, right? Just people are really getting into it.
Yeah.
Couple questions in the comments here. So Dave on YouTube says, does a co-trustee have the same power as a regular trustee in terms of adding and removing properties?
Yeah, so Dave, it depends on how the trust is written. So a co-trustee is a regular trustee. And so there are successor trustees. And if they're co-trustees, that means they work together. They work together on things. They talk and discuss and make decisions. Some trusts are written that each of those co-trustees can have what we call independent powers. So one could do something and the other could do something. But in general, they have to coordinate and work together and make sure that they're on the same page with what's going on. Now, if there's malfeasance or, you know, fraud going on, then that's something that probably the other co-trustee needs to look into. But it's certainly, usually co-trustees are of equal footing. And then if the trust very specifically says that co-trustee has those independent powers, then yes, they can act, you know, on their own. But I always tell people, don't hide the ball. Just be so transparent and put everything out there for your co-trustees and your beneficiaries to see. It's not open to the public, unlike probate court, which is very open to the public. You know, if you want some good salacious reading, just go to a probate court website and start reading the wills and the distributions of some families, celebrities. It's crazy.
Wasn't it like Prince, or he was one of the last big ones to pass and had no estate plan, and so everybody
no
could
estate
see
plan whatsoever.
Yeah.
And Aretha Franklin's court proceeding right now is drug on for years, and it reads like some bad soap opera. So
I'm sure I'll be a reality show in no time. That will be, you know, a sitcom at some point, I'm sure. Probably get some good content out of that. Okay, so a couple other questions here from Alina. I have a revocable living trust set up a while ago. It did not I did not place my rental property in it yet. Do I need to put my single member LLC by just add one page in my trust, or it has to be written by an attorney?
Yeah, so Alina, it's hard because I really can't give legal advice on a live stream. But I would say, and I'm going to make an assumption here that maybe your LLC owns that rental property. So think of it as, I always think of it as those Russian nesting dolls, right? Your rental property is in your LLC, and then your LLC is now nested inside your trust.
Yep.
So you don't retitle the rental property in the trust. You just make sure that the LLC is the owner of record of the rental property. And then you assign your interest in the LLC to your trust, and it should be appearing on your asset schedule. But I wouldn't do it myself in that regard. If you have that type of business interest set up, you probably should be consulting with a professional.
Yeah. And there's a lot of, there's a lot of online tools now. People try to use LegalZoom and stuff, but the challenge with those is, I'm not saying they're horrible, but if you're not an attorney, you're not going to know what you don't know. You don't know. You don't know what you don't know. So you don't know if it's going to be sufficient. And something like that, that's one of those things in life. It's like, you better be right. Like, you don't want to have those assets going to the wrong person or not be protected when you thought you were later on if something comes up. So that's I always recommend, like, do seek a professional. I myself do the same thing personally. I wouldn't recommend, if I wouldn't do it, I wouldn't recommend it, but I would as well see a professional. So that's me. But there's just so much to know, and nobody can know it all. And unfortunately, Google has a lot of good information, but also has a lot of misleading information in terms of what you should be doing, because everybody's circumstance is so unique. And so it really can change the solution.
Right. And you start checking boxes on a form and it generates something, and then it says, go have this notarized or witnessed, and they don't follow through with the formalities involved with that. So, I understand that it's a lot of money and it's an investment, but it is an investment well spent, and it will keep your family out of court. I sadly, I get a lot of do-it-yourself trusts that they're not clear. It's not there. And we end up going to probate court anyhow.
Right.
Not only did they spend bad money on a product that didn't have the intention that they wanted, but now we have to take all that bad, documentation and take it to court and try to figure out what the person wanted. Yeah. I say in those cases, God, they might have just been better off doing nothing, but it's, because you're still in court, you're still in the same process, you're still at those same fees. So it's really sad to me when that happens.
Yeah, absolutely. I think that's a excellent point. Annie asks, what is the best trust plan to pick up? I know that's going to vary by person, but
yeah, it really does, the circumstance. But as you said, Mike, the revocable living trust is kind of the base to start at. The revocable living trust.
Yeah, I think most people would at least benefit from getting that established. One, for all the benefits we've been talking about, for the privacy, for being able to direct where your assets go. Absolutely. I think it's well worth it. My wife and I are currently in the process of getting that established with you, Gina. So, I got to make sure I get those ducks in a row. So, I think Floofy, I love that, if I said that right. How about a transfer on death deed for property? Does the recipient need to pay tax on it?
So transfer on death deeds are, I say, fairly new to California because they've only been around for a few years now, but taxes, that's a tough question to answer. So typically there's no inheritance taxes.
Right.
But you need to make sure that if you're going to keep the house, that you get an appraisal or you get a valuation, because if you ever go to sell that house, you want to make sure that you have a new step up in the basis of that house. So you avoid those capital gains that Mike was talking about. And you could probably do a whole live stream on capital gains and investment.
I could. I have several videos on like capital gains and.
Oh, good. Yeah. So I suggest people take a look at that. But the issue with taxes on transfer and death, or actually any transfer now, and I'm speaking from a California perspective, is that under Prop 19, the property gets reassessed unless the beneficiary is a child and they're going to move into the property within 1 year. So a lot of my information is California specific. And you think about it, we really have, I call them tax lanes. I'm driving down a superhighway and I have the capital gains tax on my investments. I have income tax on my employment or any other earned income that I have, interest income. I have that as estate or inheritance tax, which thankfully in California, we don't have a state inheritance tax. And that federal limit is so high, it's not a huge consideration. But oh my God, live on the East Coast and you are definitely looking at estate taxes and inheritance taxes. And then we have the whole property tax, so those are and sales tax and vehicle tax. Like you said, there's taxes everywhere, but those are kind of the big four that I deal with on a regular basis.
Yeah, I think it was I think it was last year, Gina. I did this exercise. I don't know if I wanted to make myself depressed, but I actually tried to estimate how much tax my wife and I pay on an annual basis. If I consider every type of tax, it was $60,000 a year.
Wow.
It's by far, it's an elusive expense. You can't see it unless you actually try to piece every piece of it. And it's close to $60,000 a year is what it was. I was just like, oh my gosh, it's like, I can't believe it. But yeah, so the step up in basis, I do want to mention one of the benefits of the law is still written. The tax law it's still in the code where what step up in basis means is if someone passes and you're going to receive that asset from them. Now it could be a surviving spouse, or now if both parents have passed and now you have a situation where a child is going to receive the property, let's say like a home. What is nice is that the law is still written so that the child who's receiving the home is going to receive a step up in basis. So if your mom and dad purchased the property way back in the 70s or 80s, let's say they bought something for like $100,000 or even less, which it often was back then. Mm-hmm. Now the same home is worth $600,000, right? Or something like that. And so you get a step up. So it steps up the basis. So when you inherit it, this is your new cost basis. So if you sell it for $600,000, your cost basis is now $600,000. And so you have capital gains of zero. Now, one thing I see people do quite often, and I try to stop them if I can. People are often inclined to put their children on title early on, and it's a grave mistake. It's just, especially if they want to pass the home on anyways. One of the worst things they can do is put them on title, because when you put somebody on title, what you're doing is you're transferring they're going to be on title, but the cost basis for that individual who's going on title is going to be the same at what their parents bought it at. So now if their parents bought it for $100,000, that's their basis too. And now the home is worth $700,000. If they sell it, we're talking about a $600,000 capital gain. Mm-hmm. And that is, in terms of taxes, I mean, that's probably like, $200,000-$300,000 in taxes.
I was going to say about $200,000, I think, but yeah.
Yeah, it's a very costly mistake. And, I try to encourage people not to take that approach, especially if they want to pass that asset on anyways.
And I'll just add to that too. Putting somebody on title is a very culturally accepted with some cultures. It's it's a form of their planning, right? Yeah. And it's very patriarchal. It goes to the oldest son. Oh, he'll take care of his brothers and sisters. It'll be fine. It'll be fine. It hardly ever works.
Yeah,
I'm just telling you that I've been doing this for 20 years, and you may have the best son in the world, but you get all these other voices involved. His wife, they now have their kids. Yeah. Maybe one of his siblings made him mad, so he's like, "It's my house." So it's just not a good form of estate planning.
Yeah. No, I'm so glad you mentioned that, because that's a great example, and it's very common. I see that just within my own tax practice when people. When I'm working with somebody on their financials and their taxes, they often tell me there are other things, and this is the kind of stuff they tell me about too. So it's I can relate there. Wei Chin says, can a beneficiary keep a house in the trust until ready to sell it?
They can, but just remember, if the trust is generating any income, you're going to have a situation where the trust now is going to have to file a tax return, a 1041. Right. So you're going to have to go see Mike to do that. Yeah. And sometimes, it's good to keep it there. Just if you're going to do a quick sale, mom or dad are gone now, you're going to do an estate sale, clean the place out, and then turn it around right away. Yeah, just leave it in the trust and sell it out of the trust. That's not a problem. Because if you start distributing to beneficiaries, you might end up with 9 people on title. Well, that's 9 people that have to go to escrow and 9 people that have to sign and notarize deeds for in the sales transaction. So if it's going to be a quick turnaround, I would say leave it in the trust and the trustee can control it and get it sold and take care of it that way.
Yeah, because it's a lot easier to disperse cash than it is to disperse a piece of property.
Yeah, it sure is.
Yeah. That would be a nightmare. David says, can you connect me to a lawyer in Chicago area?
I sure can. Yeah. And Mike, I don't know if you want to put up, I have my website and they can always go on the contact us and shoot me a message. And then I will be happy to make a referral to one of my colleagues in Chicago.
Excellent. Excellent. Let me go back to the comments here. There's a couple more. We'll do kind of a lightning round on these because I know we're getting close to our time, but Great Transportation says, does a trust list items specifically or generically, such as like a car, SUV, or 2022 Ford Edge?
Good question. So in California, personal property like that, vehicles, jewelry, guns, fishing poles, and stuff, we list those generically. And then if you have specific items that you are, have value, sentimental value that you want to list, we give you a list in which to put those down. Like, okay, my pearls are going to go to this person or what have you. So, but vehicles are in and out so much, you don't want to be dealing with that in a trust. So you just list things generically.
Yeah, no, and that's how I've seen it too. Like it'll often be titled as like personal effects, or especially like furniture and things like that.
It's called general assignment of personal effects, and I tell people it's everything from Tupperware to underwear. Yeah,
exactly. Now, Going Green Mom says, do you wind up incurring charges every time you buy a different car or change bank accounts and such?
No. So here's sort of the beauty of having a trust. Remember I said, here's your box, here's your magic box, and you're going to put everything in there. You control this. You put anything in and out of this trust that you want that does not involve redrafting by the attorneys. I think you should keep a list of everything that you've changed and updated in terms of the assets in and out. So property in and out, assets in and out, that is all you. You just do whatever you want. When you go to an escrow company to close title on a piece of property, or you go to your real estate attorney, if that's the custom and practice in your state, you simply say, I'm going to take title in the name of my trust. So that's how you handle it. Now, people in and out of a trust, that's a whole different story. Don't get out your big red Sharpie and start crossing names off and, no, they're dead to me or what have you. We're going to end up in court with that because it's going to be, what are the intentions at the time and were you of a sound mind and body when you did that? So property in and out, no attorney involved, but people in and out, you should be consulting with a professional to make sure that that's done in the right way.
Yeah, absolutely. That's a great question though, because I think it's a common thing that people ask is if I need to change it, it's going to keep costing me more money to do that. So thank you for addressing that. And Going Green Mom has one additional question. I'm hoping we can answer. I'm catching up, kind of amazed. Indiana limit is $50,000 for where you have to go through probate. If you have beneficiaries on your investment accounts and low value on asset, is the trust still worth it?
That's a great question. And I will say that it depends, So beneficiaries, again, never put a minor. Don't put a minor on there as a beneficiary. That creates a guardianship and you're going to court anyhow. And then if you have real property, you might consider it. But I do have colleagues in Indiana. So if you're interested in connecting with somebody in your particular state, feel free to reach out. You can send me a message through the website and I will be happy to make a qualified referral to you.
Awesome. Thank you, Gina, for that. So I'm sure people really appreciate you doing that. Jersey Boy says, hi, Mike, can I have a will and a trust or both? Have my IRA and financial institutions with beneficiaries so it can transfer to my children and put house in trust to avoid probate tax?
Yeah, that's a common way to do that. So you can have a will and a trust together, and that's how we operate. So we have your trust. Here's your trust, and then we do a very special will. It's called a pour over will. And a pour over will, the only beneficiary named in that will is the trust. So here's Mike's trust, and then Mike has a will that says, I, Mike, give all of my worldly goods and assets to Mike's trust. So it pours it over in there. Because if there's ever anything that you forget to put into your trust, we can use that will as a safety device to pour it over and get it back in there. So they work together. But you shouldn't name different beneficiaries in your will than you have in your trust. The trust is the main thing, and then the will feeds into the trust. So that's how it works. But yes, you can have a trust for just your house. You can keep your, you typically would keep your retirement assets outside the trust. But then if you have your adult children who are over the age of majority in your particular state, sometimes it's 18 or 21, you should name the trust as the very last contingent beneficiary of all of your assets. So just think of it as your safety net, your insurance policy, because God forbid, what if you lost your children? Or what if, something could happen? You always have a place for it to land.
Yeah, that's really important. Because nobody knows, none of us know how life's going to go, right? Just it's a mystery. That's part of the fun. But we want to be prepared for it as much as possible. Jay asks, should a 529 for a minor child be added to a trust?
Yeah, typically the custodians won't let you do that. So you are the custodian of those funds. And when I say custodian, I mean financial institution. And every financial institution has their own rules and policies and procedures. So you have to, get in there and ask some of the questions. But 529s, you're the custodian, and then the beneficiary is already your minor child for qualified educational expenses. And then, of course, there's that provision where you can roll it over a family member if they don't use all of the funds. So 529s are a little unique and don't get funded into the trust, but I would work with the financial institution that holds those funds for you and see what recommendations they have.
No, that's excellent. Yeah. Some of those situations, I encounter questions similar to that sometimes in my practice. And sometimes I just have to, let's talk to your broker and see what they say.
Exactly. You've got to talk to that particular financial institution because, like I said, they all have their own rules and they got to send it up to corporate or back office or legal or something like that. And but there are ways on the custodian piece of it, like you're the custodian for your child as the beneficiary. You can have a backup custodian name. So in my very case, my husband is the primary custodian for my daughter's 529 plans. And then I'm the backup for him. So he's primary and I'm the backup. And they might let you have more than one backup. So that's something to just check in with them.
Yeah. Now, as we start to wrap things up, Gina, I was going to just a couple last questions here. So what I should say, how often should somebody look at updating their trust?
Yeah. So major life events, births, deaths, marriage, and typically those happen, it seems like in a 3 to 5 year span. We try to stay on top of reaching out to our clients, on a regular basis, but, looking at about every 3 to 5 years, giving them a little nudge and saying, hey, we miss you. And has anything significant changed? And by golly, a lot of times it has, there's new spouses or somebody passed. And so it's just good to kind of get everything out and refamiliarize yourself with it. And, I get folks all the time in here, oh, we drafted this 30 years ago. And oh my God, I can't believe we did that.
Yeah. Well, I had a situation where it was when I was working at one of my other firms at the time. It was a true story. Somebody had passed away and apparently they never updated their trust. So it was so sad. So all of the assets, a huge chunk of them went to their ex-spouse. Even they had remarried. They had been with this new spouse for a very long time, but they never updated that trust again. So, and if that's what the document says, that's what it says, and that's how it goes.
Yeah.
Unfortunately. So,
so that happens. So second quick public service announcement. If you're looking at beneficiary forms to make sure that you did not name your minor child, it would be a good time to just, do an inventory of those beneficiary forms and just check in with your HR or your broker or your financial institution. Hey, what are the beneficiary designations on this account? Just to make sure they're current and updated for you.
Is it okay if I share your website here real quick, Gina, before
please. Yeah.
So this is Gina's website. This is the LeguriaLaw.com. And one thing I really like about Gina is, she's just a family-owned business. So you're not going to, there's a lot of law firms out there, but Gina gives you personal as you can see, she's very good at explaining what she does, and she's great at educating clients what a trust is and how their estate plan works. So that's one of the reasons I feel so comfortable referring business to her. But Gina, I don't want to forget to mention, but you also help people form businesses. Is that right?
Yeah, we do. So if you're a sole proprietor, a small business owner, we do formation of LLCs, limited liability companies in California, as well as corporations, S Corps and C Corps. So, or if you have real estate, if you have rental properties and you want to insulate from liability, the rest of your estate, you can form an LLC and put your rental properties in there. And that way, if somebody gets hurt or something happens in that property, they can't come after the rest of your trust or the rest of your estate that you own. So we do a lot of that.
And I really encourage a lot of people, they have rental properties, and I see it all the time when I'm working with their accounting and their taxes and things like that. But I really encourage those individuals to place those properties in an LLC or some type of entity structure, because one lawsuit, and if it's not in an LLC or if it's not protected, I mean, they can go after you for everything. Versus if it is an LLC, they're limited to what's in that LLC. I'm sure that there are exceptions to that, but I mean, for the most part, it's pretty much just whatever you place in the LLC is what they would have access to. So something to consider. And then the last thing I want to mention, Gina, and I would love to hear your thoughts on this. This is not a trust question, but in regards to businesses, so I see a lot of people they're using LegalZoom. They're going online. They're doing like the bare minimum to get an operating agreement, or they don't have one at all. And often they're forming an LLC, for example. Let's just use that entity structure. Why is having an operating agreement so important?
I like to think of it as the rules of the game. Everything has rules. Baseball, sports, chess, Monopoly. There are rules of the game. And you want to plan for, especially if you have, a partner involved or another member of the LLC involved. It spells out what happens when something happens. So a split or a growth or a merger or a dissolution, it just kind of lays out all of the framework to take care of everything that could happen in that particular entity throughout its existence. And, I hear from people all the time, well, my handshake and my word are gold. And I'm like, maybe they are for you, but they may not be for the other party.
Sure.
And you may not be dealing with the other party. If they die, you're now dealing with their spouse or their children. And are your verbal agreements over a handshake and a cup of coffee or a beer or something going to hold any water? They may not. And you will spend a god awful lot of money trying to prove what the agreements were. So I say, have it all in place. It may feel very formal and, but you want to make sure that you are protected. And especially in this day and age, if it's not written down, if it's not in paper, it doesn't exist.
Right. And if it didn't happen on social media, it doesn't exist either.
Well, that's true too. Yeah. So I can just see people having a meeting and holding up their phone and saying, okay, Jerry and I agree to this. So
yeah, right. Or something on TikTok. It's probably what the Generation Z is doing at the moment.
Yeah.
But hey, Gina, I really appreciate your time. And thank you everybody who came to the stream to ask questions and engage in the comments. It made it a lot of fun.
Yeah. Great questions.
I hope everybody got something out of this. So Gina works here in Modesto, California, where I live, and I recommend her to pretty much anybody. If you're able to work with her, she's a gold mine of knowledge and just such a wonderful person to work with. And I wouldn't bring her on here if I truly didn't mean that. So
thank you. Aww.
And so, feel free to, this video is going to be saved. So if you guys want to share this out to family members, friends, feel free to do so they can have access to this knowledge. So, because a lot of people don't know some of these things because it's something that we're just never taught in school. And I don't see school ever teaching this. So, I hope I hope everybody got something out of this. And thank you so much for your time, Gina. I just am so
You're
grateful
very
for you.
welcome. Thank you to your viewers.
All right. Well, you have a good rest of your evening, and everybody out there have a wonderful night. So thanks so much for tuning into the stream.
Thanks.
All right. I'll see you in the next one. Bye, guys.